In this lecture, we take up the question of warranties. Now, in sales law, a warranty is an assurance or a guarantee by the seller about the quality and features of the goods that are being sold or leased. The UCC has numerous rules governing product warranties as they occur in sales contracts. Now, at one time, caveat emptor was the rule in sales contracts. Caveat emptor is a Latin phrase meaning let the buyer beware. And the idea was the obligation is on the part of the buyer to inspect the goods and ensure the goods meet the specifications called for in the contract. And once the transaction was complete, then the seller was free of any representations regarding those goods. But we have replaced that caveat emptor, the buyer beware approach, with a consumer-oriented approach, in which now, under the UCC, 3 types of warranties can arise in a sales contract. The term warranty oftentimes is said to resemble the term promise, meaning it's a promise about the good that is being sold. And there's actually 2 aspects to the promise. When we talk about a warranty, there are 2 aspects of warranty that we're interested in. And the first is a warranty to the good. This is the kind of warranty that you probably are familiar with. It's a guarantee, a promise that the good will meet the specifications called for in the sales agreement. But there's also a warranty of title, and a warranty of title is in a transaction, the seller warrants that they have a good and valid title to the goods being sold, and they have the ability to transfer that title to the buyer. So in this lecture, we're going to study the role of the warranty in commercial transactions. At the end of this lecture, you should be able to answer the following questions. What are express warranties? What is the implied warranty of title? What is the implied warranty of merchantability? What is the implied warranty of particular purpose? Do warranties apply to third parties? And finally, can warranties be disclaimed? Let's start with that warranty of title. Warranties protect title to goods. Remember, a warranty is an assurance or a guarantee by the seller about the quality and features of the goods, but it is also a guarantee that the seller has the right to transfer title to goods. So the term warranty applies to both goods and title. When I sell something, I am warranting both the good, the thing, and the title, which is the right of ownership to the thing. So sellers will warrant they have good title to the goods they sell, and they will also warrant that the transfer of title is rightful. They have the right to do that. Now, sellers will also warrant that the goods will be delivered without encumbrances, meaning the goods are free of any liens. A lien is a claim or a charge or some sort of liability against a good. And when a seller sells a good, he is warranting that the goods are free of any liens. Now, this arises most often in the case of a creditor's security interest, a buyer who purchases goods that have been that are subject to a creditor's security interest. And by that means it's an interest in the goods that secures payment or performance of an obligation. When you borrow money from a bank, you have to pledge collateral. That collateral, those goods, now have a security interest attached to them. And if a creditor who has a superior security interest can take those goods from a subsequent buyer, the buyer can recover from the seller for breach of the warranty of title. So merchant sellers also warrant that the goods are delivered free from any claims by a third party, a bank or another institution, another customer. A merchant will warrant that the goods are free of any third party's claim. Now, a lease contains a warranty of quiet possession. And what the warranty of quiet possession means is that while the owner of the goods has a title to the goods, the party who has executed the lease has a right to possess the goods and therefore has a superior right to possess or use the goods during the lease term. Now, any of these warranties that we've discussed so far, title warranties, can be disclaimed or modified by specific language in a sales contract. So we set out language that is specific, written, that says this warranty does not apply. I can sell you a good, and in that sales contract I can say I may or may not have title to the good. If I disclaim the warranty of title, obviously that's going to affect the price you give for the good, the cost of the good. So that's how we protect that. Now there are three kinds of warranties we're going to talk about: express warranties, implied warranties, and statutory warranties. Now an express warranty arises when a seller makes an oral or written promise ancillary to an underlying sales agreement regarding the goods' quality or description or performance. So an express warranty arises when a seller indicates that the goods conform to any affirmation or promise of fact about the goods, or conform to any factual description of the goods made, or conform to any sample or model of the goods. Express warranties are often found in a seller's advertisement or brochure or promotional materials, in addition to being made orally or in a provision in a sales agreement. Now, to create an express warranty, a seller does not have to use formal words such as guarantee or even warranty. It's only necessary that a reasonable buyer would regard the representation as being part of the basis of the bargain. Basis of the bargain is not defined in the UCC, but generally it means that the buyer must have relied on the representation at the time of entering into the agreement. So a reasonable buyer need only regard the representation as part of the basis of the bargain. Now, what can be problematic is a phenomenon known as puffing. And puffing is really a statement of value, and a statement of fact can create an express warranty, but if it is sales talk, if it is a statement of opinion, it may not constitute an express warranty. So a seller's statement of opinion is not necessarily an express warranty. If a seller says this is the best pizza in the world, well, that does not indicate that the pizza is objectively the best in the world. The law looks on that as a statement of opinion. Seller's talk. Oftentimes, these statements deciding whether they are an express warranty or not, the courts will look at context, because the line between puffery and express warranties is not always clear. We don't always know where that line falls. Similarly, the line between puffery and fraudulent misrepresentation is also unclear. If I sell you a car and I say this car can make it from Houston to San Antonio on one tank of gas, you could argue that that's just a puffery. That's sales talk. Yes, it gets good gas mileage. Or if, in fact, you are stranded somewhere outside Schulenburg, you may claim that that statement was fraudulent misrepresentation, that you felt like you did not need to refill your gas tank because the statement provided that you would make the trip without incident. So puffing can be a problem. Now, the law also provides for implied warranties. And when we're talking about an implied warranty, it's one that the law derives by inference from the nature of the transaction or the relative situations or circumstances of the parties. Under the UCC, merchants will impliedly warrant that the goods they sell are merchantable and may be fit for a particular purpose. An implied warranty often arises from a course of dealing or usage in the trade. Now, this warranty of merchantability is part of every sale of goods made by a merchant. Every sale of goods made by a merchant, and remember, a merchant is someone who deals in goods of the kind that are being sold. In every sale of goods by a merchant, there is an implied warranty of merchantability. Therefore, if a merchant's in the business of selling ski equipment, every time he sells a pair of skis, he is making an implied warranty of merchantability. Now, this implied warranty of merchantability only applies to merchants, as you might guess. So a neighbor who is selling her skis at a garage sale does not make an implied warranty of merchantability. Now, what do we mean by merchantable? Well, to be merchantable, goods must be reasonably fit for the ordinary purposes for which such goods are used. So they must be of average, fair, or medium grade quality. They must pass without objection in the trade or market for goods of the same description and be adequately packaged and labeled as provided by the agreement. And the goods must conform to promises or affirmations of a fact made on the container or label. The implied warranty of merchantability applies to every sale of goods by a merchant, including merchantable food. So the serving of food or drink is also subject to the implied warranty of merchantability. If you go in to buy a pie, for instance, a cherry pie, the question, and you break your tooth on a cherry seed, a cherry pit that's included in the pie, the question might come up with, was that a merchantable pie or not? Courts usually look to see what was the consumer's expectation. Could a consumer reasonably expect to find a cherry pit in cherry pie? Now, in contrast, of course, consumers would not expect to find, say, a piece of glass in your soft drink. So, whether the implied warranty of merchantability has been breached or not, in the context of food, we have to look to see, well, what was the context of the food? Now, there are other implied warranties in addition to the implied warranty of merchantability. And the one we're going to be most interested in is the warranty of fitness for a particular purpose. Now, this is a warranty imposed on any seller who knows that the buyer is relying on the seller's skill and judgment to select suitable goods. that the goods being sold are fit for the particular purpose for which the buyer wishes to use the goods. And goods can meet the test of merchantability, but not be fit for a particular purpose. So how would this arise? Well, if you were going to enter into a desert race, for instance, you're going to be entered into the Baja 500, you're racing through the desert, high temperatures, high speeds, you want a motor oil that will be able to handle that high temperature and those high speeds. So you go to the automotive supply place and you ask for oil that will meet those particular needs. They may sell you oil, which is merchantable, which is of ordinary value, but not be fit for those particular purposes. And if in fact your car then breaks down during the race, because of the failure of the oil, the seller has probably breached the implied warranty of fitness for a particular purpose. Now, sometimes trade usage may also create an implied warranty if it is common in the industry for a warranty to be applied. Then a court may be willing to find a warranty in place and support a breach of warranty claim. The Magnuson-Moss Warranty Act, there's a lot of this in your book, and under this Magnuson-Moss Warranty Act, the rule of express warranties was changed with respect to consumer transactions, under the theory that consumers need extra protection. If a seller does not have to give a written warranty for consumer goods, but if they do, and the price of goods is more than $10, the warranty must be labeled as either a full warranty or a limited warranty. Full warranties require free repair or replacement of the defective part. And if the product cannot be repaired within a reasonable time, the consumer must have the choice of either a refund or a replacement. Now, if a warranty is limited, the language of a limited warranty must be conspicuous. A limited warranty is any warranty that does not meet all the requisites for a full warranty. If an express warranty is a limited warranty, that fact must be conspicuously designated. Now, the Magnuson-Moss Warranty Act only covers express warranties and does not cover or create an implied warranty. Sometimes warranties can protect third parties as well, parties who are not the buyer or the seller, that in fact the seller's warranty may extend to not just the buyer, but to the buyer's household and guests. So if a seller sells a good, if a merchant sells a good, and the good is defective and causes harm, say, to the buyer's husband or other family member, that family member can bring a claim even though there was no warranty between that person and the seller. So a seller's warranty, in fact, could extend to any reasonable and foreseeable user, anyone who may come into contact with that good. Seller's warranties, in fact, can extend to anyone injured by the good. If, in fact, a lawnmower is sold by a merchant to a buyer and the buyer subsequently resells it to another third party, if that third party is injured by the lawnmower, that third party may still have a claim for breach of warranty against the seller, even though the seller did not make any sort of representation to that third party. Liability under a warranty can be limited, meaning the seller can protect itself to some degree. First of all, let's look at the issue of multiple warranties. What happens when there are multiple warranties involved? Well, it will depend on whether the warranties are consistent. If 2 or more warranties are made in a particular transaction, then usually the law will construe them as cumulative and not exclusive of one another, meaning the warranties are read in conjunction with one another and are meant to be cumulative, one warranty on top of the other one. Express and implied warranties could also be construed as cumulative if they're consistent with one another. But if the warranties are inconsistent, then special rules will apply. If the express and the implied warranty are inconsistent, the express warranty displaces an inconsistent implied warranty. So the express warranty is presumed to have been the one that the parties were most concerned with, and therefore that's why it will take the place of the implied warranty. A sample also takes precedent over an inconsistent general description. If I give you an example of a product, that's more important than a description of the product. If there are technical specifications involved, technical specifications displace the inconsistent sample or general description. So technical specifications will trump those 2 items. It can be difficult to disclaim a warranty. Courts view warranty disclaimers with disfavor. The legal system wants sellers to warrant the goods that they are selling. And therefore, it can be difficult to disclaim a warranty. Now, nevertheless, the UCC does permit warranties to be disclaimed or limited as long as there is specific and unambiguous language, and the disclaimer is done in a manner that protects the buyer from a surprise. So the manner in which a seller can disclaim warranties varies with the type of warranty. So if it's an express warranty, whether that's oral or written, a seller can disclaim all express warranties by including a written disclaimer in the contract, making sure that the buyer is aware of that disclaimer. For the implied warranty of merchantability and fitness for a particular purpose, a seller can also disclaim those warranties by using an expression such as is, or with all faults. As is, where is oftentimes a phrase you see, for instance, in used car sales. However, the language must be clear and unambiguous to state that there are no implied warranties. Now, to specifically disclaim an implied warranty of merchantability, the seller must mention the word merchantability. It doesn't have to be written, but if it is, the writing must be conspicuous. How do you show conspicuousness? You put it in bold letters, or you put it in all caps, or in a different font. Same with the disclaimer of the implied warranty of fitness for a particular purpose. The disclaimer must be conspicuous, must be in writing. And the writing in this case does not have to mention the word fitness. It's sufficient to just say there are no warranties that extend beyond the description herein. Now, there are federal and state statutes that make certain disclaimers Unenforceable, meaning sometimes there are laws that prevent a seller from disclaiming a warranty. And a buyer prevented from claiming breach of warranty may have other options as well. There's options beyond simply breach of warranty that would enable a buyer to recover. So warranty disclaimers are still possible. Express warranties can be negated or limited through the use of clear and unambiguous language. Making sure that this disclaimer is brought to the customer's attention at the time the contract is formed. Implied warranties, a little simpler to disclaim. Make sure that the merchantability disclaimer mentions the word merchantability. And if you are going to disclaim an implied warranty of fitness for a particular purpose, you may do so by saying there are no warranties beyond those that have been expressed. There are other factors that may limit liability under a warranty. If in fact a buyer has examined the goods or a sample or model as fully as they wanted to, then there may be no implied warranty with respects to defects that are found if those defects were present in the sample or model. If the buyer refuses to examine the goods on the seller's request that he do so, there's no implied warranty with respect to evident defects. The parties can reduce the statute of limitations for a suit on warranty. The parties can, in their sales contract, reduce the statute of limitations to whatever period is possible. Now, ordinarily, a cause of action for breach of a contract under the UCC must be filed within 4 years after the breach occurs. However, the sellers can agree to a shorter time period. So in our sales contract, we could agree to a limitation of only 1 year, for instance. And that's very common in warranties, wherein all warranties have a 1 year statute of limitations, despite the fact that ordinarily you would have 4 years. So in conclusion, what did we learn today? We learned that warranties protect title to goods, that there are express, implied, and statutory warranties, and that liability under a warranty can be limited. Thanks for listening.